The UK government plans to fundamentally change the way in which visa holders may acquire indefinite leave, otherwise known as settlement. They would like individuals to acquire status under what's called an earned settlement system. So, what's wrong with that? Well, there are a number of concerns with the proposals which I will address in this video, as well as look at how individuals may mitigate against that should the proposals indeed become law. I'm Carla, an immigration consultant. I've worked in immigration for a number of years in various organisations, including the Home Office, the government department responsible for UK immigration matters. I also have a popular channel on TikTok by the same name, UK Immigration Explained, where I have over 140,000 followers. The earned settlement system will allow visa holders to qualify for indefinite leave under a new baseline period of 10 years rather than 5. And that will be on the basis of 3 key areas: suitability, integration, and contribution. So that individuals will be permitted to reduce the 10-year baseline period to indefinite leave depending on their ability to meet one of the pillars that has been published in the recent policy document of November 2025. Now, I don't plan to go into the proposals in significant detail because I've done that in a recent video, which you can find here. But as well as being able to reduce the 10-year baseline, depending on the individual circumstances, rather than that being attached to a particular immigration category, the Home Office also proposed that they could add time to the 10-year baseline depending on the individual circumstances. For instance, if there was overstaying involved. So that's the proposals in a nutshell. Now, there are some good things within the proposal. So maybe we can start there. Now, one of them is around high earners. High earners will be recognized within the proposals so that if an individual has earned £125,140 for each year of a 3-year period preceding the application date, they could potentially apply for indefinite leave after 3 years rather than 10, because they can reduce the time period by 7 years. Now that's quite good because such individuals pay a lot into the tax system. After all, in the tax year from April 2025 to April 2026, such an individual would expect to take an annual take-home pay of around £78,000. Their monthly income will be £10,500, but they will actually take home £6,500 per month, or just under. So recognizing their contribution in this way is quite helpful, as well as the fact that, number 2, the Home Office has stated that individuals who are family members of British citizens will, if they meet the immigration requirements, have a pathway to indefinite leave after 5 years. So in some ways, there is no change there. Individuals that are sponsored by their British partner or British parent, or under the adult dependent relative visa to join or accompany their British family member to the UK, can go ahead and know that they have the certainty of securing indefinite leave after that 5-year residence period. And that's good for such individuals to know. And also, the proposals will recognise wider contribution, charitable endeavours, so that individuals who are engaged in charitable work, whether formal or informal, could potentially have the 10-year baseline reduced from 10 years to perhaps 7 years, maybe even 5. That is going to depend on the individual circumstances, but it is very helpful to know that that is available to them. But there are some concerns, and I'm going to list out 5 key concerns. Now, one of them, funnily enough, is around high earners. So yes, whilst the Home Office will recognise those that earn a high income and are paying a great deal into the tax system, the fact that they are able to acquire indefinite leave after 3 years, as opposed to someone working in the public sector who is expected to wait until they've resided and worked in that role for 5 years, seems a little bit imbalanced. Because those in the public sector cannot necessarily expect, by and large, to earn such a high income, but they are contributing significantly to the UK and its infrastructure. So it seems unwise in some ways that they are expected to wait 5 years, whilst a high earner can wait only 3 years to qualify for settlement. Now, there is an argument to say that if individuals in the public sector acquire indefinite leave, they may leave that job after, say, 3 years, and then the country doesn't get that benefit anymore. But the same could apply to a high earner who, once they acquire indefinite leave, could become a consultant in a less lucrative role. And therefore, those tax receipts are also lost after that time. But the aim of the guidance is to recognise the contribution already provided by the high earner in 3 years, and perhaps that could also be applied to public sector workers. So that is something that could make this proposal seem somewhat elitist. And it's interesting that in a recent committee hearing, this was something that was highlighted by them as a potential concern. The other potential problem is around family members. So yes, family members of British citizens will have a pathway to indefinite leave after 5 years, and that's a good thing. But what is absent from the proposal is around the family members of those with indefinite leave in the UK or other qualifying category. Asylum seekers, for instance, are no longer able to rely on family reunion. They are now expected to sponsor their family members under the family category of the immigration rules. They will be expected to sponsor their partner, it would appear, for a 10-year period, which can be quite difficult if they have to show that they meet the minimum income threshold. Also, there are going to be concerns with those that have indefinite leave or settled status under the EU settlement scheme and are settled in this country. They've lived here for a number of years, and yet they are being treated slightly differently when it comes to sponsoring their family members, so that they are not given a surety themselves that their partners or their children can join them in the UK for that 5-year period, knowing that they will get indefinite leave at that point, but instead are expected to wait 10 years. So that suggests as well that the partner of a person who is settled in the UK, who does not fit within the family pillar, could, if they are a high earner, apply for indefinite leave after 3 years rather than the 5 years that they would qualify under if they were the partner of a British citizen. These things need to be ironed out so that it makes sense to all concerned. In terms of number 3, again, I go back to the public sector. Because the public sector workers are expected to wait 5 years before they qualify for indefinite leave, but as I said, there is no reason why this could not be reduced to 3 years in keeping with the high earning category. They too should be recognised for their contribution, given that not all public sector workers earn a high salary of £50,000 or £100,000 plus. So again, something to be looked at in more detail, perhaps by the government. Honorary mention goes to English language. Within the guidance, the Home Office states that individuals who have a pathway to indefinite leave after 10 years may reduce that by 1 year if they meet the higher English language threshold of level C1. However, that would suggest that all applicants from majority English language speaking countries will at least be able to reduce their baseline figure from 10 to 9 years as standard. And that seems to be a little bit unfair because they're always going to have that advantage. So perhaps this needs to be reviewed so that it doesn't penalize individuals who are from non-English language majority speaking countries but are expected to sit a higher English language test, if nothing else, just to meet that ability that others will automatically benefit from. But in terms of number 4, this is around children. Children who are not the dependents or family members of British citizens will be expected to wait 10 years before they qualify for indefinite leave under this earned settlement system. And that seems unreasonable and doesn't really take into account the interests of children. Because an individual who has settled status in the UK could effectively sponsor their child to join them at the age of, say, 16, 17, and that child would not become eligible for indefinite leave until they are 26, 27. So a child will go to school, sixth form, do their A-levels, probably a degree, maybe even a postgraduate degree, and still not have qualified for indefinite leave until they've been in the country for 10 years as standard. Now that seems to be quite unwise and really unfair to children. And in fact, this was again raised at the committee hearing, but also raised by research, which stated that this could impact a very high number of children, quite unfairly. But at number 5, the fact that the government is looking to make this retrospective is something that needs to be carefully considered by the Home Office. Now, I've touched on this in another recent video as to why I believe transitional arrangements will come into being. So in summary, the Home Office is suggesting that these proposals will not happen from the date that the law is enacted and therefore apply to new applicants from that date, but that it should apply to those that have not yet acquired indefinite leave in the UK, thereby placing a number of individuals in limbo. Because if you've entered the UK under a skilled worker visa, believing that you will qualify for indefinite leave after 5 years, the Home Office is suggesting that you will suddenly have to wait an additional 5 years. Now, there is the principle of legitimate expectation, and this has already been tested and discussed by the courts, so that it wasn't possible for the Home Office to make changes to a person's ability to acquire permanent status by changing the rules after the fact. And I cannot see how this would apply here, though I stress this information is guidance only, it's not legal advice. But in my opinion, I believe that the principle of transitional arrangements will apply because of legitimate expectation. However, the fact that the government would even suggest making these proposals retrospective has caused a lot of stress to existing visa holders. It's also created a sort of them and us system where individuals that have yet to acquire indefinite leave never feel settled, which goes against the very essence of the document published in November 2025, which seeks to integrate and recognize individuals' ability to contribute to the UK, and also the government's white paper in May 2025 that also talked about the need for integration in the UK. So overall, we have a government saying on one hand that it wants to introduce immigration laws that further integrates visa holders into the UK, recognises their contribution, their ability to give to UK society, which will be recognised by reducing the baseline period to indefinite leave, but then on the other hand makes it harder, more difficult and more protracted for individuals to acquire such status, including children. So overall, that's the problem with the proposals by the government, and I'm sure there are many more. And I'd be really interested in your comments as to whether you agree, disagree, or have any other concerns of your own. Now, of course, there will be individuals out there that say this doesn't go far enough and that no one at all should be able to secure indefinite leave. I'm not speaking to you if that's you, because you'll never be satisfied. But if you do have comments, let me know. So how can individuals mitigate against this if this does indeed become law? Well, I think it's going to need some strategic planning. Individuals that are negotiating contracts to come to the UK under a skilled worker visa, for instance, may look at the threshold and decide that it's worth paying more tax by going into a higher tax band, knowing that you could overall reduce your time frame to indefinite leave. So if you have an employer that's prepared to offer you £124,000 to work in the UK, you might want to negotiate and raise that to £125,140 to take you into a pillar that allows you to apply for indefinite leave after 3 years. And that will be beneficial to you because not only are you saving on immigration health surcharge fees over the long term, but you just are able to get out of the immigration system to a degree and will no longer become subject to immigration time restrictions. You will have that permanent status. So that is something that can be done from very early on in the process. As well, if you are planning to sit an English language test and you are so capable, you may wish to sit a higher test at level C1 and use that to support your application, and thereby that can be used in an application to extend your leave and also for indefinite leave, subject of course to the rules in place at the time. So it's thinking ahead and planning ahead that's going to be important, not just planning to enter the UK, but what is your pathway to indefinite leave going to look like? And also, if you are someone that has indefinite leave or settled status in the UK and you would like to sponsor your partner or children to join you, it may be time to think about applying for British citizenship, because if you do so, it will allow you to go ahead and sponsor your family members knowing that they will have a pathway to indefinite leave after a 5-year period rather than 10. This can be beneficial, particularly for any children that you are sponsoring. So that's potentially how we can mitigate against that. And I say potentially a lot because this is not yet law. These are proposals. The government has reasserted its intention to follow through with this so that it could become law in April 2026. But we, of course, will watch this space. There may be some changes along the way as the consultation currently underway with the public comes to an end, and there is more debate within the parliamentary process. So please make sure to like and subscribe for more updates as this goes through the different channels to become law, again, if indeed it does, and also to be informed of other areas which I'll be touching on in future. Look out for a video coming up about the skilled worker visa. Great to have you here, and thank you again.